of the entire Blakely Advocacy Institute at UHLC. I just want to say thank you to everybody who has participated, everybody who has helped put this together. Big thank you to Vincent and Elkins for sponsoring, and a big thank you to my team of the Honorable Judge Christine Weems of the 281st, who we could not have done this without. And of course, Chase Keller, thank you so much for all your hard work and helping me put this together. Honestly, could not have done it without you. Now for this final round, we have a lovely panel joining us. Presiding, we have Ryan MacLeod, partner at Kherkher Garcia. We're also super glad to have the Honorable Justice Julie Coutiss joining us of the First Court of Appeals. And last but not least, our own Honorable Christine Weems, Judge Christine Weems of the 281st District Court. Now, without further ado, also want to thank our bailiff, Andrew Jacobs, the moment you've all been waiting for, our competitors. So we have today on prosecution, Team 16, Trey Gifford and Brett Hargis, and they are facing up against the defense today, Team 1, Laura Gomez Duarte and Youssef Abdelhafiz. I am going to now blend into the background and let the presiding judge take over. Good luck, guys.
Thank you for that. Good afternoon, counsel.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
All right. Thank you and congratulations on making it to the final round of the Hippard Open. I know that all of you worked extremely hard, and I know that this is one of many things on your plate. And so before we get just too serious about ourselves here, I do want to tell you that you should take a moment and take a deep breath and take some pride in yourselves, because just reaching the finals is a tremendous accomplishment. So please be proud of yourselves and look forward to this today. So first thing I'm going to do then, I'm going to call the case. It's State of Lone Star versus Dr. John Martin. Make your announcements, please.
Yes, Your Honor. Trey Gifford here for the State of Lone Star, joined by my co-counsel, Brett Hargis.
Good afternoon.
Good afternoon.
Yes, Your Honor. Representing the defendant in today's case, Dr. Martin, is Youssef Abdelhafiz. That's spelled Abdelhafiz, alongside my co-counsel, Ms. Laura Gomez Duarte. That's spelled Gomezduarte.
And defense counsel, I presume that we can waive with a reading of the indictment and that Dr. Martin has entered a plea of not guilty. Is that correct?
Yes, Your Honor.
All right. Prosecution, let me start with you. Is there anything we need to take up before we get started with openings this afternoon?
Yes, Your Honor. There's a series of housekeeping matters that we'd like to address.
All right. Let's start with exhibits. I know that there were 11 marked exhibits, and I know that y'all were able to talk a little bit. Y'all make any agreements, counsel?
We were not able to make any agreements, Your Honor.
Let me make sure. Prosecution and defense went to a breakout room. There are 11 exhibits, and there's not a single agreement.
An attempt was made.
Okay.
But we weren't able to reach any agreements.
Defense counsel, is that your recollection of the conversation as well?
Yes, Your Honor, that's correct.
Okay. Prosecution, why don't you start off and whatever housekeeping matters we have, let's get underway, okay?
Yes, Your Honor. May we assume that all witnesses have been constructively sworn in?
Absolutely.
And may we also assume that the defendant has been properly arraigned?
Yes, sir.
And may we assume that the jury charge will be read constructively before closing arguments?
Yes, sir.
And finally, Your Honor, may we assume that evidentiary arguments will be handled outside, constructively handled outside the presence of the jury?
Yes, counsel.
Thank you. That is all our housekeeping matters, and we are ready with a motion in limine when you are.
Defense counsel, do you have any housekeeping matters?
Yes, Your Honor, just two housekeeping matters. At this time, the defense would like to invoke Rule 615, the constructive sequestration of all witnesses, barring the party representative, Dr. Martin. Additionally, Your Honor, we would ask that the defense expert, Dr. Walker, be allowed to sit in and listen to the entirety of the trial today, as it will be pertinent in coming to our conclusions today.
That is so ordered. What's your next matter?
Secondly, can we, given the Zoom nature of today's trial, may we assume that any screen sharing is done outside the presence of the jury until a request to publish is made?
That's agreed.
Yes, Your Honor. With that, the defense is ready to move into its motion in limine in 3 parts.
Perfect. Prosecution, let's start with you. What you said you had some motions in limine. Give me the substance of those.
Yes, Your Honor. We have one motion in limine in just one part. As you know, this is a case about the death of David Kherkher. David Kherkher was a rock and roll legend. Now, he had a series of underlying health concerns, but he was found with a series of prescription drugs in his system. We are alleging that Dr. John Martin recklessly administered these drugs and caused his death. We anticipate that defense counsel may reference a Rolling Stones article in order to prove truths about David Kherkher's relationship with drugs or lack thereof. We believe that this article is hearsay, and it has quotations within it that would be hearsay within hearsay, and we do not believe it's appropriate for the trial today.
And defense counsel, what particularly on the hearsay within hearsay, do you have an expert who is going to rely upon that article, or how do you overcome that hearsay objection?
Your Honor, we do have an expert that relied on that article in coming to her conclusions. Now, the expert is allowed to testify as to her conclusions based on that article. However, the defense has no intention of bringing the Rolling Stones article into evidence, and will simply be asking witnesses to just testify to their personal knowledge about any statements that they may have made, as well as the expert's conclusions after analyzing that article.
So, Mr. Gifford, what I'm going to do is I'm going to allow questioning regarding the article, and obviously, if they seek to admit the exhibit, obviously, I think that's going to be a bigger issue here. But I think right now we'll allow questions. Of course, this is a motion in limine, so you can approach again at the right time.
Thank you, Your Honor.
Yes, sir.
That concludes our motion in limine, and we're ready to proceed with opening arguments.
Thank you, Mr. Gifford. Defense counsel, you said you had 3. Do we really need to make 3, or can we agree to follow the rules of evidence today?
Your Honor, we can bring it down to 1 if you'd like.
Let's do that. That'd be great. Thank you.
Your Honor, at this, as you know, today's case is about the mysterious circumstances surrounding Mr. Kherkher's death. Now, we anticipate that the prosecution is going to try to either allege or indicate in some way that the defendant, Dr. Martin, was co-conspirating with Bree Trevino. Now, we anticipate that this co-conspiracy allegation, if the prosecution goes into it, it's substantially more prejudicial than probative, as the prosecution has not charged Bree Trevino with any co-conspirating crime, has not charged with Bree Trevino in any way related to the crime that they have alleged against the defendant. Trying to tie Bree Trevino as some sort of co-conspirator that worked with the defendant only goes to substantially prejudice the jury against the defendant. And that, seeing as this is the first time the defense would have heard this argument and heard this allegation, it would be substantially more prejudicial, seeing as we were not given time to prepare a defense against that allegation.
Mr. Gifford, let me maybe first off ask you about the co-conspirator theory allegation. Is that something, is that going to be an issue here in terms of the presentation of the prosecution's case?
Your Honor, we don't believe so. We haven't charged Bree Trevino with anything. Bree Trevino is going to be, her evidence is going to be shown today through a deposition. She's unavailable through Rule 804. We're going to read some of that deposition, or we hope to. We believe conversations between Bree Trevino and Dr. Martin are highly relevant because it goes to motives of Dr. Martin, and it reveals his mindset and his mind state in the hours preceding the events at hand. But we have no argument of co-conspiracy here to offer you.
Defense counsel, your motion is well taken, but I do agree. I think what Mr. is getting at here is that there's an issue of culpability here. There's a requirement on the state. So I'm going to deny your motion again, just like I told the prosecution. Feel free to approach. Are there any other housekeeping matters, anything else that we need to keep up or take up right now? Prosecution, I'll hear from you first.
Quickly, Your Honor, since the rule has been invoked, we're going to ask that our expert witness be allowed to stay throughout the trial as it's an expert witness. And
that's absolutely fine.
Thank you, Your Honor.
Anything else, prosecution?
No, now your time. We are ready to proceed with opening arguments.
Defense, is there anything else you have at this time?
No, Your Honor, defense is ready for opening statements.
All right, and who will be making the opening statements for the state?
I will, Your Honor. Trey Gifford here for the state.
All right, Mr. Gifford, you may proceed.
May it please the court. Ladies and gentlemen, a doctor's priority should always be the care of his or her patient. This is a case about what happens when a doctor forgets that cardinal rule of medicine. This is a case about the defendant, Dr. John Martin, who, the evidence will show you today, muddled the lines between doctor, drug dealer, and friend. You'll see through this evidence that Dr. John Martin recklessly administered 2 drugs to David Kherkher. You'll see how she acted not only as a doctor, but as a drug dealer as well, and maybe in a misplaced sense of friendship. These drugs killed David Kherkher by stopping his heart. Now, why would Dr. John Martin do that? Why would she forget the cardinal #1 rule of medicine? Ladies and gentlemen, the evidence today will show you that this defendant was living lucratively in a 4-bedroom cabana on John Martin's estate. Ladies and gentlemen, forgetting that #1 rule and blurring those lines between doctor, drug dealer, and friend was easy and it was lucrative to do. Ladies and gentlemen, let me back up just for a moment. My name is Trey Gifford, and with my co-counsel, Brett Hargis, we represent the state of Lone Star today. We represent the state against the defendant, Dr. John Martin, who has been charged with the manslaughter of David Kherkher. Now, ladies and gentlemen, who is David Kherkher? That question may sound ridiculous. David Kherkher is a music icon. David Kherkher was a legendary musician who went by the name Special K, and he died because of the reckless decisions made by the Dr. John Martin. Members of the jury, it's true that the state owns what we call a burden of proof. You may have heard of it. We must prove this manslaughter beyond a reasonable doubt. We must prove to you that John Martin committed reckless homicide. We must prove that he acted recklessly, that he knew about a risk, and he acted despite this known risk. But ladies and gentlemen, this burden is not insurmountable. Beyond a reasonable doubt does not mean beyond any possible doubt. If that were the case, nobody would be held responsible for their actions in this state. Ladies and gentlemen, to meet that burden, we're going to provide to you evidence. You're going to hear from Dana Kherkher. Dana Kherkher is Special K's 17-year-old daughter who saw her father on the day of his death. Dana goes by Little Kit, and she's going to come in and tell you about those painful memories. She's going to tell you that on May 9th, 2019, she heard her father complaining about pain. She went to her father's bedroom to see what was wrong, and she saw Dr. Martin leaning over David Kherkher, Special K. Dr. Martin was giving an injection. She's going to tell you how the defendant, Dr. Martin, saw Dana Kherkher. He saw Dana Kherkher and he left the room. Dana Kherkher is going to tell you about how she saw her father grow pale and sweat and begin to shake. Little K, Dana, she rushes out of the room to get the defendant, Dr. Martin. When they come back, her testimony and the evidence will show that he dug through his medical bag and started giving shots to David Kherkher, Special K. Dana Kherkher is going to tell you that this is when she saw her father turn from gray to white and stop breathing. I want you to listen to I want you to listen to Dana Kherkher's testimony and what Dr. Martin told David Kherkher, Sr., Special K, as he was administering these drugs. Members of the jury, next you're going to hear from Dr. Chris Jensen, who was the medical doctor that performed David Kherkher's autopsy. He's going to tell you what killed David Kherkher. He's going to tell you about the things that were in those vials. He's going to tell you how the first shot was propofol, a powerful sedative meant for surgeries and for hospice. The sedative was not supposed to mix with the hydrocodone already in David Kherkher's body. You're going to hear from Chris Jensen that Dr. Martin should have known about this hydrocodone as David Kherkher's doctor his neighbor, and his friend. He is also going to tell you about that second vial. And you'll hear testimony today that this second vial was one of the worst mistakes the defendant could have made. The second vial was full of adrenaline that was meant to restart David Kittner's failing heart. But the evidence will show that this adrenaline aggravated an already dire situation and caused the immediate death of David Kittner. Finally, you're going to hear from Bree Trevino today. Now, Ms. Trevino wasn't able to testify here in court today, but you'll be able to hear from her deposition. And you're going to hear how Bree Trevino was celebrating with John Martin the day David Kittner died. It was their anniversary. And you're going to hear exactly how they were celebrating right before Dr. Martin went to meet with David Kittner and recklessly killed Special K. Ladies and gentlemen, we also anticipate the defense to put on a case. We anticipate the defense is going to call Dr. Chris Jensen. Now, Dr. Jensen is going to tell you, we believe, about David Kittner's long struggles with drug abuse. But ladies and gentlemen, you'll hear no testimony today from anybody that believes Special K, David Kittner, died of a recreational drug overdose. David Kittner's not on trial today. Special K died from poorly administered prescription drugs. This kind of medication, you'll hear from the evidence today, is used by responsible doctors in controlled environments. Finally, we anticipate the defense is going to call the defendant, Dr. John.
Objection, Your Honor. May we approach?
You may approach.
Your Honor, the prosecution cannot reference whether or not the defendant will testify. This is a violation of his Fifth Amendment right, his right to not self-incriminate. By the prosecution bringing up that the doctor could testify and may testify, this is a violation of his Fifth Amendment or her Fifth Amendment right. And at this time, the defense moves for a mistrial, Your Honor.
Your Honor,
you may, Mr. Gifford. What's your response to that?
Your Honor, I said that we anticipate the defendant to call, we anticipate the defense to call the defendant, Dr. John Martin. This has been discussed pre-trial, and this is something we anticipate to happen. While we do revere the Fifth Amendment, we do not believe that we've transgressed upon that Fifth Amendment right today.
Mr. Gifford, I would tend to agree that you are getting very close to a fine line with respect to the Fifth Amendment. So I would suggest that you move along, and obviously I will deny the motion for mistrial, but it is well taken. Thank you, counsel. You may proceed, Mr. Gifford.
Thank you, Your Honor. Ladies and gentlemen, at the end of today, my co-counsel Brett Hargis is going to come and give you his closing statements. And after those statements, you're going to go back and you're going to deliberate about the evidence and about the facts that you have just heard. You're going to remember that the state does own that burden of proof, but that reasonable doubt standard is not insurmountable. And when you review the facts and you review the evidence, you must come to the decision that justice demands, that you hold the defendant, Dr. John Martin, accountable for his actions and guilty for the homicide of David Kittner. Thank you.
Thank you, Mr. Gifford. Does the defense wish to make its opening statement at this time?
Yes, Your Honor.
Defense, you may proceed.
May it please the court. Relax and take a breath. That was the treatment that Dr. Martin believed was necessary. Good evening, ladies and gentlemen of the jury. My name is Youssef Abdelhafiz, and alongside my co-counsel, Ms. Laura Gomez Duarte, we represent the defendant in today's case, Dr. Martin. Now, we've heard about how Mr. Kittner was a rock star who lived the rock and roll lifestyle, the lifestyle that you might expect from a famous rock and roller, traveling across the country, working on his music, and engaging in recreational drugs. This type of lifestyle and the stress that comes along with it, of course, took a toll on Mr. Kittner. That's why he lived with his personal physician, the woman who took care of Mr. Kittner so that he could continue to live as a rock star. But as he got older, Mr. Kittner's health began to diminish. Now, what we do know is that on May 9th, 2019, Mr. Kherkher was struggling with breathing. So Mr. Kherkher called for Dr. Martin's help. He called the woman he always trusted, the woman who had been taking care of him for years now. So Dr. Martin went to go check on Mr. Kherkher. And she determined that all Mr. Kherkher needed was to relax and take a breath. That's it. Mr. Kherkher was older and he needed to give his body rest. After making this determination, the doctor then leaves after Mr. Kherkher's daughter barges in. Members of the jury, the doctor didn't do everything perfectly. And we're going to be upfront about this with you. You see, this is when the doctor made a mistake. She had forgotten to take her bag with her after being confronted by Miss Kherkher Jr. And as soon as the defendant, Dr. Martin, remembered that she had left her bag, well, she went back to grab it. What did she see when she got back? You'll learn that she saw Miss Kherkher Jr. slipping a syringe into her boot. Once again, Miss Kherkher Jr. yells at the defendant, Dr. Martin, to leave. So again, Dr. Martin, she leaves. And while Miss Kherkher Jr. and Mr. Kherkher are alone together, well, that's when Mr. Kherkher goes into cardiac arrest and passes away. You see, the mistake the doctor made wasn't what the prosecution is telling you. It was that Dr. Martin left Mr. Kherkher alone with Miss Kherkher Jr. and a medicine bag. Now, we understand that the death of a musician such as Mr. Kherkher, it's felt across the country. We mourn the death of Mr. Kherkher, and we understand that you may have feelings about Mr. Kherkher and his passing. But it is important today for all of us to separate our feelings from the facts. You see, our feelings cloud our judgment and can lead to injustices. It's the facts that should guide your decision today, not your feelings. Now, the prosecution has accused Dr. Martin of committing manslaughter. They have to prove this to you beyond a reasonable doubt. This is the highest burden in our court system. They have to prove to you that Dr. Martin recklessly caused the death of Mr. Kherkher. They have to prove to you that Dr. Martin was aware of, but disregarded a substantial and unjustifiable risk that caused Mr. Kherkher's death. And they have to prove that to you that it was in fact Dr. Martin who took that risk. I want to remind you, members of the jury, as Dr. Martin sits before you today, she is innocent. Throughout the entirety of today's case, Dr. Martin is innocent. Dr. Martin is presumed innocent until and only if the prosecution meets their heavy burden. You see, the defense today, we don't have to prove a single thing. We don't have to call any witnesses. We don't have to discuss any of the evidence. We don't have to admit a single exhibit. Because if the prosecution fails to prove that Dr. Martin was aware of this risk, or fails to prove that Dr. Martin's actions led to Mr. Kherkher's death, then you must return a verdict of not guilty. So let's talk about why the prosecution won't meet this burden. Well, the prosecution has talked about a slew of medications. And while they may be able to prove to you that Mr. Kherkher had different medications in his system, they won't be able to prove to you when they got there. They won't be able to prove to you how much was taken. They won't be able to prove to you who gave these drugs to Mr. Kherkher, or even if Mr. Kherkher himself took these drugs. They have to prove beyond a reasonable doubt that either Dr. Martin gave Mr. Kherkher all these drugs, or was aware that Mr. Kherkher had recently taken drugs before administering propofol. If you believe that Dr. Martin did not know Mr. Kherkher had any drugs in his system, well, this is reasonable doubt. Now, if they somehow prove beyond a reasonable doubt that Dr. Martin was aware, they have to prove that Dr. Martin was the one who actually injected propofol or adrenaline. If you think Mr. Kherkher himself took those drugs, that is reasonable doubt. If you think David Kherkher Jr. gave Mr. Kherkher those drugs, then that is reasonable doubt. At the end of today's trial, my co-counsel, Ms. Laura Gomez Duarte, will come before you, and she will review all the evidence and all the testimony that we have heard today. And she will remind you about the moment Mr. Kherkher passed. She will go over all the holes in the prosecution's story and all the reasonable doubts that you may have. She will show you how the prosecution has failed to meet their burden. She will ask you to find Dr. Martin not guilty. Thank you.
Thank you, counsel, for the presentations. Mr. Gifford, on behalf of the state, is your first witness ready to be called?
Yes, Your Honor.
All right, you may proceed.
I believe my co-counsel, Brett Hargis, is going to handle this first witness, Your Honor.
Good afternoon, Mr. Hargis. Call your first witness, please.
Thank you, Judge. The prosecution calls Dana Kherkher Jr. to the stand.
Ms. Kherkher, you understand you've been sworn to tell the truth?
Yes, Your Honor.
All right, counsel, Mr. Hargis, you may proceed.
Thank you, Judge. Good afternoon, Ms. Kherkher. Thank you for being here.
Good afternoon.
Ms. Kherkher, would you please introduce yourself to the jury?
Yes, my name is Dana Kherkher, but my friends call me Little Kit.
How old are you?
I'm 17 years old.
Where do you live, Ms. Kherkher?
I currently live here in Armadillo Lone Star with my Uncle Rufus now.
Ms. Kherkher, can you tell us why you're here today?
Yes, I'm here to tell you about my dad's death.
Who was your dad?
His name was David Kherkher Sr. He was also known by his stage name, Special K.
Can you tell us a little bit more about your dad?
Sure. He was a famous musician. He played all kinds of music from rock and roll to rap, and then recently to country and Western music. He was very talented.
Ms. Kherkher, where were you living at the time of your dad's death?
I was living with my dad.
Okay. Now, Ms. Kherkher, I know this might be difficult for you, but I need to ask you some questions about the day of your dad's death. Is that okay?
Yeah.
Okay. Ms. Kherkher, do you recall what day it was that your dad died?
I will never forget that day. It was May 9th, 2019.
Where did your dad die?
He died in our house in Armadillo.
Can you tell us what county and state Armadillo is located in?
Yes, Armadillo is located in Bexar County, Lone Star.
Thank you, Ms. Kherkher. Your Honor, let the record reflect that venue has been properly established.
The record will so show.
Ms. Kherkher, do you recall who all was at the house on May 9th, 2019?
Yes, so I was there. My dad was there. There was a lot of people there. His girlfriend was also there. And then Dr. Martin and Dr. Martin's girlfriend was also there, and then house staff.
You mentioned a Dr. Martin. Who was that?
That is my father's, or was my father's, personal physician.
Ms. Kherkher, would you recognize Dr. Martin if you saw her in the courtroom today?
Absolutely. I'll never forget her face.
Your Honor, if I could ask the defendant to briefly turn their camera on.
Please do so.
Now, Ms. Kherkher, if you see Dr. Martin in the courtroom, could you please identify her by an article of clothing they're wearing, maybe?
Yes, Dr. Martin is wearing what looks like a dark blue blazer and a light blue shirt.
Your Honor, let the record reflect that the defendant has been properly identified as Dr. John Martin.
The record will so reflect.
All right, Ms. Kittner, what do you remember about the day your dad died?
So I remember at some point my dad was yelling in the hallway of our house.
Where were you at this point?
I was in our fitness center.
Okay.
Down the hall.
What, if anything, did you do when you heard your dad yelling?
Well, it seemed I was a little concerned. So I went to go check on him and I found him in his bedroom.
What did you see when you entered his bedroom?
Well, as soon as I walked in, I saw Dr. Martin injecting something into his arm with a syringe and then kind of sneakily put it back in her pocket, her jacket pocket.
Was Dr. Martin facing you when you walked in the bedroom?
No, she was facing the opposite direction. I don't think she saw me.
What did Dr. Martin do with the syringe that she had?
She had slipped it into her jacket pocket. Seemed like she was trying to hide it.
Now, at this point, did you hear Dr. Martin say anything to your dad?
Yes. He told my dad, "You just can't leave this stuff alone, can you?"
What did you see what, if anything, did you see Dr. Martin do next?
Well, after he administered whatever was in that syringe into my father, he turned around, and I think that's when she saw me, she looked pretty surprised.
Now, Ms. Kittner, do you recall seeing anything on the bedside table next to your dad?
I think I saw a pill bottle.
Okay. Your Honor, permission to share screen.
Permission granted.
All right, Ms. Kittner, can you see this?
Yes.
Counsel, has this exhibit been admitted into evidence?
No, Your Honor, I'm laying the foundation.
But why are we publishing it if it hasn't been?
I'm sorry, Your Honor. I thought I understood that this would be outside the presence of the jury.
All right, if we're going to do this outside the presence, proceed.
Thank you, Your Honor. Ms. Kittner, I'm showing you what's been previously marked as Exhibit 1. Do you recognize this?
Yes, that's the pill bottle I saw next to my dad's bed.
And does this appear to be a fair and accurate depiction of the pill bottle you saw by your dad's bed?
Yes.
Okay. Your Honor, at this time, I offer Exhibit 1 into evidence.
Any objection?
Yes, Your Honor. Objection as to hearsay.
Objections overruled. Proceed. Exhibit 1 is admitted, but you may proceed with your questioning, counsel.
Thank you, Your Honor. Ms. Kittner, can you read who this is prescribed to?
Yes, it's prescribed to David Kittner Jr., myself.
And who was the prescribing doctor?
Objection. Calls for hearsay.
What's your response to that?
Your Honor, this has already been offered into evidence, but I would respond that it's not being offered for the truth of the matter asserted, rather the effect on the reader when she saw this bottle.
Yeah, I'd agree with that. It's overruled. You may proceed.
Ms. Kittner, who is the prescribing doctor on this pill bottle?
Dr. John Martin.
Had you ever seen this pill bottle before May 9th, 2019?
No, I've never seen it before.
Now, Ms. Kittner, what is the next thing you remember happening on that day?
Well, after I saw Dr. Martin give the syringe to my dad and he saw me, he walked out of the room. Then that's when my dad started turning really white. He was shaking, convulsing really bad. It was super scary.
Did Dr. Martin ever return to the room?
Eventually, I had gone back to get him and it took him several minutes to come back into the room.
What did Dr. Martin do when she returned to the room?
Well, when she got into the room and saw how my dad was, she started panicking and looking through her bag for different medicines, and then just started putting stuff into my dad's arm, injecting him with a needle.
What happened next?
All of a sudden, my dad's face turned white and gray, and he stopped shaking. And I'm pretty sure he stopped breathing at that point.
Ms. Kittner, what did you do when your dad stopped breathing?
Well, it all happened so fast, but I went to call the ambulance as soon as I could, and I think they got there within 3 minutes.
What, if anything, did the EMTs do when they arrived?
They were trying to bring my...
Objection, Your Honor, calls for expert testimony.
I don't think we're there yet. Mr. Hargis, you may proceed with your questioning.
Ms. Kittner, what, if anything, did the EMTs do when they arrived?
Well, they immediately started working on my father. I think they were trying to bring him back to life. They were doing CPR and stuff like that.
Did you see them inject anything into your father?
No, I did not.
Okay. Where was Dr. Martin during all this? Do you know?
I really don't know where she was. I didn't see her until later that day, actually, until after my father was pronounced dead.
Ms. Kittner, do you have any experience injecting medicine into people's veins?
No, I've never done that before in my life.
Ms. Kittner, at the time of your dad's death, did you know what propofol looked like?
No.
Thank you, Ms. Kittner. I have nothing further at this time.
Duarte, do you wish to cross-examine this witness?
Yes, Your Honor, may I proceed?
Absolutely.
Ms. Kittner, on May 9th, 2019, you were in the room with your father, correct?
Yes, once I heard something in the hallway, I went to go check on my dad.
And when you went to go check on your dad, that's when you allegedly saw Dr. Martin in the bedroom with your father, right?
That's when I did see her in the room with my father administering some kind of medication with a syringe.
And at this time, your father was laying in bed when Dr. Martin was allegedly injecting your father, correct?
That's what I saw.
And then it's your testimony that Dr. Martin left the room, right?
Well, they were kind of talking, and then she turned around, and that's when she saw me, and I believe she left the room at that point.
Okay, so you'd agree with me, yes, Dr. Martin left the room, right?
Yes.
And then you called and Dr. Martin came back, correct?
Yes.
And that's when you allegedly saw Dr. Martin inject your father again, right?
Yeah, she was pretty frantic about it.
And during this time, your father was still in bed, correct?
Yes.
And you just testified on direct examination, Mr. Hargis asked you, and your father was convulsing at this time, right?
Yes, he was convulsing and turning very pale.
He was very pale and he was still in bed, right?
I believe so.
And at no point that day did you see your father in a chair, correct?
I think after everything happened, I don't recall.
So you'd agree with me that you don't remember seeing your father in a chair ever that day, correct?
I don't think so.
Is it your testimony today that you might have seen him in a chair then?
I don't remember.
So then you would agree with me that there are things about that tragic day that you don't remember.
Well, I remember the important things and what I saw, but it all did happen very quickly.
Okay. Now, Ms. Kittner, you mentioned on direct examination that you currently live with your uncle Rufus, correct?
Yes.
Now, Ms. Kittner, you were aware that upon your father's passing, a will was executed, correct?
I learned about this, yes, after he died.
And that's when you inherited your father's estate, correct?
That's what his will said.
I just need a yes or no, Ms. Kittner. You inherited your dad's estate, right?
I'm sorry, Ms. Duarte, there's a proper objection for that if you need the court's help. Move along, please.
Yes, Your Honor. Ms. Kittner, you inherited nearly over $410 million, correct?
Yes, but that's not going to bring my father back.
Ms. Kittner, let me stop you, Mr. Duarte. Ms. Kittner, you've made a few gratuitous comments. Let me remind you that you're not an advocate. Please answer Mr. Duarte's questions, okay? Thank you.
Yes, Your Honor.
Thank you.
For the clarity of the record, Ms. Kittner, you inherited over $410 million, correct?
Yes, I believe that's what the value of his estate was.
No further questions at this time, Your Honor.
Brief redirect, Your Honor.
Yes, brief.
Ms. Kittner, were you aware of the amount of your dad's estate at the time of his passing?
No, I was not.
Were you aware that you were the sole beneficiary of that estate at the time of his passing?
No.
Thank you. Nothing further, Your Honor. May this witness step down.
Yes, the witness may be released. Prosecution, you may call your next witness. Thank you, Ms. Kittner, for your time.
Your Honor, at this time, the state calls Dr. Chris Jensen.
Dr. Jensen, welcome. You understand you've been sworn to tell the truth?
Yes, I do.
All right, you may proceed with your examination of this witness.
Good afternoon, sir.
Good afternoon.
Would you please introduce yourself for the record and for the jury?
My name is Chris Jensen. I'm a pathologist practicing out of Cheapside, Lone Star.
And doctor, how did you initially get involved with this case?
I was the pathologist called to do David Kittner's autopsy the day that he died.
And did you perform this autopsy?
I did.
And have you come to a conclusion about David Kittner's death and what killed him?
Yes, I have.
And doctor, are you prepared to share that conclusion with us today?
Yes, I am.
Doctor, before we get into that, I think it's important that we know who you are. You mentioned you're a pathologist. Now, what exactly does that mean?
Well, I'm a medical doctor. Pathology is just my specialty. Pathologists study tissues and other materials taken from the body. I'm an expert in analyzing biopsies, so while the patient is still alive, as well as autopsies, as you know, when the patient is deceased.
Doctor, you mentioned you're a medical doctor. Can you tell me about that education and what it took to get there?
Well, I studied microbiology in undergrad at Lone Star Technical Institute. And after that, I went to Johns Hopkins Medical School, where I completed a medical degree with honors.
And doctor, can you tell us about what you learned in your undergraduate degree and your graduate degree, and tell us a little more about your formal education?
Sure. Well, studying microbiology taught me how the body works on a molecular level. Going to medical school reinforced those lessons and taught me how the body works as a whole. I learned about things like medication, ailments, and the complicated systems that make up the human body.
Doctor, what did you do after you graduated from Johns Hopkins with honors?
I did a residency in Tombstone, Arizona, before I came back to practice medicine in Cheapside, Lone Star.
And what did you learn in your residency?
Well, that's where I applied all the things I learned in school in a very practical way. I worked as a pathology resident, so I helped in autopsies and biopsies and studied different effects on the body.
And you mentioned you did your medical degree in Johns Hopkins, and you did your residency in Arizona, and then you came back to Lone Star after those programs?
Yes, that's correct.
And what brought you back to Lone Star?
Because this is my home. You know, I love Lone Star.
Doctor, since your residency, how long have you been practicing medicine?
I've been practicing medicine in Lone Star for 15 years.
And during that time, have you conducted autopsies?
Yes, absolutely.
And have you determined causes of death?
Yes, I have.
About how often would you say that you've done those things?
Honestly, more than I can count.
Doctor, you performed the autopsy on David Kittner, correct?
Yes, that's correct.
And did you review anything else as you prepared for your conclusion?
I did. So I reviewed his external features. I performed surgery to look at his internal organs. I did an extensive review of David Kittner's heart, I reviewed all relevant medical information about David Kittner, and I reviewed his toxicology report.
Doctor, you mentioned you performed David Kittner's autopsy, and you mentioned that you've come to a conclusion about his death. Are those conclusions based on your skill, your knowledge, your training, and your experience as a medical doctor?
Yes.
And in forming your opinions, did you rely upon materials or information that other doctors will typically rely upon?
Yes, I did.
And do you hold these opinions to a reasonable degree of medical certainty?
Yes.
Doctor, I now want to talk about those conclusions. In your medical opinion, what killed David Kittner?
David Kittner died of a massive coronary event caused by drug interactions.
Doctor, you mentioned a massive coronary event. His heart gave out. Is that what that means?
Yes, that's correct.
Now, you mentioned drug interactions that prompted this coronary event. Can you tell us a little bit about that?
Yes, there were 3 drugs in Mr. Kittner's system that led to his death: propofol, hydrocodone, and adrenaline. The first 2 put great stress on Mr. Kittner's heart, and the addition of the third, that being adrenaline, caused his heart to absolutely explode.
Doctor, I want to talk about those 3 drugs in turn now. What is hydrocodone?
Hydrocodone is an opioid-based prescription pain medication, and it's one of the most commonly abused drugs in the United States.
Doctor, you also mentioned propofol. Can you tell us what propofol is?
Yes, propofol is a powerful sedative that's used for sedation and anesthesia. It's primarily, or actually it's exclusively administered through injection.
Doctor, what is propofol used for in the medical field?
It's used for things like surgery or hospice care.
And were there any conditions regarding David Kittner that would require this sedation or this anesthesia?
No.
And did David Kittner, per your review, have a prescription for propofol?
No, he did not.
And doctor, how much propofol was found in David Kittner's body?
Per my autopsy report, 3 times the prescribed amount of propofol.
Doctor, per your expertise, what happens when somebody takes that amount of propofol?
Propofol, 3 times the prescribed amount, that can lead to a remarkable hallucinogenic high.
And doctor, per your medical expertise, can you tell us whether propofol is readily available to the public?
No, it's a powerful sedative, so it isn't widely available to anybody, really only doctors and specialists, so I'd say no.
Doctor, you just mentioned that doctors typically have access to this drug, but do they typically carry around this strong sedative with them, like propofol?
No, definitely not, because it's used for mainly, like I said, hospice and surgeries.
Doctor, if you believe a patient is using hydrocodone, is it ever appropriate to administer a powerful sedative like propofol?
If a doctor believes his patient is using hydrocodone, it's likely to cause a fatal cardiac event. It would only be appropriate in incredibly remarkable emergencies, in my opinion.
Doctor, would a reasonable doctor know what prescription drugs his patients are taking?
Yes.
Objection, Your Honor. It's improper opinion.
Describe that for me. What's the basic improper opinion as to what?
Yes, Your Honor. This witness cannot speculate into the mindsets of every doctor to determine whether or not it's normal for a physician to be aware of every medication that their patient is on. In fact, there are different ways that a doctor may or may not be aware of medications their patient on and typically rely on their patient. This kind of opinion is speculative in nature.
I'm going to sustain objection, but Mr. Gifford, I think you can get there if you're more specific in your questioning. Proceed.
Thank you, Your Honor. Thank you, Your Honor. Doctor, in your practice and in your education, the doctors you've been around and as you practice yourself, have they always or typically known what their patients are taking?
Objection, Your Honor. We re-urge this objection. Opposing counsel hasn't laid any foundation to show how these doctors would know who these doctors even are. We just ask that opposing counsel lay the foundation before asking that question.
Agreed, sustained.
Doctor, you have taken classes in ethics, correct?
Correct. All medical students do.
And per those classes in ethics, have you also taken classes in patient management and things?
Yes.
And have you learned what a reasonable doctor would do in certain situations?
Yes.
And is it important for a reasonable doctor to know what drugs his patients are taking?
Yes.
And is it important for a reasonable doctor to know these drugs when administering something as powerful as propofol?
Yes, I'd say it's imperative to know that.
Doctor, what happened to David Kherkher when hydrocodone and propofol were introduced into his body?
Objection, Your Honor, to argumentative and assumes facts not in evidence. May I be heard?
That's overruled. You may proceed, Mr. Gifford. He's been tendered as an expert here. I believe he's qualified to give this opinion. You may proceed.
Thank you, Your Honor. Doctor, just one more time. What happened to David Kherkher when hydrocodone and propofol were introduced into his body?
His heart began to fail.
And you mentioned adrenaline. Why do you believe adrenaline was in David Kherkher's body?
Well, it is naturally made, but I believe because of the amount that I found in his body during the autopsy, that it was administered here because his heart started to fail. So it was sort of a means to kickstart it.
And what did this kickstart do to David Kherkher's heart?
It caused it to absolutely explode.
Doctor, did you see this heart?
I did. I held it.
And can you tell me about it?
It was absolutely shredded. All those drugs at the same time destroyed it.
Doctor, have you performed autopsies on the bodies of older patients?
Yes.
And have you performed autopsies on the bodies of patients with drug abuse concerns?
I have.
And can you tell me how those hearts have compared to the hearts of David Kherkher?
They can have some serious scarring and aging, but nothing like this. Nothing like the instance with David Kherkher.
Doctor, what stopped David Kherkher's heart?
It was the combination of propofol, adrenaline, and hydrocodone.
Doctor, if you did administer propofol with somebody with a drug abuse concern and they began to seize, what would you do next?
I would attempt CPR and other non-invasive procedures, but I would not administer adrenaline. At that point, I would say you're 100% dooming your client, your patient, to death.
Thank you. No further questions, Your Honor.
Defense, cross-examination, you may proceed.
Yes, Your Honor. Dr. Jensen, you reviewed Mr. Kherkher's most recent medical records, right?
That's correct.
So based off of what you reviewed, you're aware that Mr. Kherkher did not have a prescription for any type of painkiller?
Yes, I'm aware of that.
Now, you'd agree that propofol is typically not lethal by itself, right?
Yes.
Now, let's talk about some of the things you can't tell us. You were not at Mr. Kherkher's house when he passed, right?
No, I was not.
You also didn't review the depositions in today's case.
No.
Now, you can't tell us who injected Mr. Kherkher with adrenaline, right?
No.
Now, you said something on your direct examination. You said that the amount of adrenaline that was found was not a natural amount of adrenaline, right?
Correct.
Is it your testimony today that you learned that from the toxicology report?
I learned that in my autopsy as well.
And so something as important as that would be imperative to include in your autopsy report, right?
Yes.
So you must have included it, right?
That was a few months ago. I would need to see the autopsy report to remember every word that was in it.
Yes, Your Honor. At this time, permission for the defense to screen share outside the presence of the jury, the pre-marked Exhibit 3, the doctor's autopsy report.
Yeah, permission granted.
Doctor, can you see this autopsy report?
Yes.
This is your autopsy report that you conducted, right?
Yes.
And there appears to be a fair and accurate copy, right?
Correct.
Nowhere in this autopsy report does it have an amount for adrenaline, right?
No, there is no specific amount of adrenaline.
Okay, so you, just to be clear, you didn't include that in your autopsy report.
No, I only included it in my opinion.
Well, your opinion was on that autopsy report, wasn't it?
Yes, it was.
And it was not in that opinion that was on your autopsy report, right?
I'm confused by your question.
The opinion in your autopsy report, the
It's
adrenaline
not.
amount wasn't there, right?
Hold on. Dr. Jensen, first off, question and answer. I'm not confused by the question, but defense, will you please re-ask it one time for Dr. Jensen?
Yes, Your Honor.
Thank you.
Dr. Jensen, in your opinion, located in your autopsy report, it does not state the amount of adrenaline.
No, it does not.
In fact, if it was injected in, you can't tell us when it was injected.
No, I can't.
Now, you relied on the toxicology report, right?
Yes.
That report doesn't tell you how much hydrocodone was in Mr. Kherkher's system.
No.
It also doesn't tell you when the hydrocodone got into his system.
Is that a question?
Yes, it doesn't tell you when, or it doesn't tell you when the hydrocodone got into his system, right?
No, it is not.
And it doesn't tell you who gave Mr. Kherkher that hydrocodone.
No.
In fact, your own autopsy report doesn't answer any of those questions.
No.
Now, the toxicology report and the autopsy report, I just want to be very clear. It doesn't tell you how much propofol was in Mr. Kherkher's system, right?
No.
So on direct examination, when you said per my autopsy report, there was 3 times the amount, you didn't include that in your autopsy report?
No.
Now, it also doesn't tell you how much propofol was found inside of Mr. Kherkher.
No.
It doesn't tell you when it got there.
No.
And it doesn't tell you how it got there.
No.
But Dr. Jensen, you believe Mr. Kherkher gave himself propofol, right?
At the time when I filled out the autopsy, that is what I put. I do not specifically know, but that is what I put in the autopsy.
Dr. Jensen, just to bring you back to my question, you believed Mr. Kherkher gave himself propofol when you created your autopsy report, right?
No, I wouldn't say I believe, but we're talking about a homicide case or a manslaughter case.
Objection, Your Honor, non-responsive.
Staying. Please only answer the question that's being asked.
So let me ask this one more time. You believe Mr. Kherkher gave himself propofol when you created your autopsy report, right?
Yes.
Thank you. No further questions, Your Honor.
All right, thank you. May this witness be excused?
Yes, Your Honor. No further questions.
All right. All right. State prosecution, call your next witness.
Your Honor, the state wishes to call Bree Trevino by deposition. She's been stipulated in stipulation 16 as being unavailable today.
I assume there's no objection to that, right?
There is no objection to the calling of Bree Trevino, Your Honor.
All right. Understood, admitted. Anything else? From the
Yes, Your
state?
Honor, yes, Your Honor. We would like to read portions of the deposition into the record.
All right. Do we need to do that, or can we all just stipulate we know what they are?
Brief response, Your Honor.
Sure, defense, please.
I apologize. I may have misunderstood the question. We don't object to the call. We don't object to the calling of Bree Trevino. However, we will be objecting to specific lines that the prosecution intends to read in. Would Your Honor like to handle that on a line-by-line issue or as it comes up?
But let's do that then. That helps me. I wish we would have been more specific a minute ago, but that's okay. Let's proceed then with the question and answer from the deposition. And please, defense, raise your objections at the necessary time.
Yes, Your Honor.
You may proceed, Mr. Hargis.
Thank you, Your Honor. Page 1 of the testimony of Bree Trevino, lines 1 through 8. Question, would you state your name for the record? Answer, my name is Bree Trevino. Where do you currently reside? Muleshoe, Lone Star. How long have you lived there? Since Special K bit the big dust. And before that, at the Kittner Mansion in Armadillo. Now reading from page 2, lines 6 through 19.
Objection, Your Honor. May we approach constructively?
You may.
Now, the defense objects to this under 403, substantially more prejudicial than probative, as well as character evidence, Your Honor. This is going to be testimony that describes David Kittner carrying around bottles of alcohol, baggies of white substances, things of those nature. However, the Bree Trevino never actually witnessed Mr. Martin ingest any of these products or substances. In fact, the toxicology report and the autopsy report both conclude that cocaine was not in Mr. Kittner's body on May 9th. The reading of these portions would try and paint Mr. Kittner as some sort of alcoholic and drug addict who's abusing cocaine.
Mr. Hargis, what's your response?
Yes, Your Honor. As you know, we're required to prove the elements of manslaughter, which includes that Dr. Martin was aware of a substantial and unjustifiable risk. Now, Bree Trevino also lived in the same house as Dr. Martin, as Mr. Kittner, as did Dr. Martin. This evidence will go to show that Dr. Martin should have been aware that Mr. Kittner was still using drugs, and thus goes to show that it was an unjustifiable risk for him to inject propofol when Mr. Kittner was still using drugs.
May I respond briefly on those grounds?
You may, counsel. And when you do, my concern, and I just want to be open with both of you, my concern here is that we're talking about acts of observation rather than consumption or ingestion. And I don't want to create any sort of a misleading perception to the jury. So help walk me through that. And let me actually go back to you, because I think that may have been directed to you. Mr. Hargis, what would be your response to that concern?
Yes, Your Honor. For the sake of completeness, we could also read in lines 24 through 25 and line 1 of page 3 that shows that Trevino didn't actually witness Mr. Kittner taking the drugs, just that she saw the drugs.
I think that cures the issue for me, and so I'm going to overrule the objection. Thank you, counsel. I appreciate that discussion. You may proceed.
Thank you, Your Honor. Starting at line 6, page 2. Did you ever observe Kittner to be intoxicated in the last 6 weeks of his life? Kittner intoxicated? What a surprise that would be. Yes, I saw him wandering around the big house holding bottles of vodka, or bourbon, or wine just about every day, just about every time of day. Did you actually observe him drinking any alcohol in the last 6 weeks of his life? No, I actually never saw him swigging the stuff. Did you ever observe Kittner taking what you knew to be drugs during the last 6 weeks of his life? I saw him in his master bedroom on a couple of occasions during that time when he had a white powdery substance in a baggie in his hand, smiling that dopey smile he got when he was high. When was the last time you saw David Kittner wandering around with a white powdery substance in his hands? The day before he died. And then going down to line 24, did you actually see Mr. Kittner take or consume cocaine at any time during the last 6 weeks of his life? No, I never actually saw him ingest any cocaine during the last 6 weeks of his life. Then, Your Honor, I would like to continue on page 3, lines 2 through 5.
And defense counsel, just to shorten this up a little bit, do you have any objections to the remaining testimony, the remaining deposition?
Yes, Your Honor. We also have objections on page I apologize, I'm scrolling down. We have objections on page 34 of the case packet, page 4, Bree Trevino's deposition.
I'm there. What line, sir?
Yes, that will be on lines 7 through, or I apologize, not 7. I apologize. On the previous page, page 3, page 33 of the case packet, on line 19 through 21, as substantially more prejudicial than probative, there's mention of sharing a joint with Dr. Martin. However, there's no testimony or evidence to show how much of that joint Dr. Martin had smoked, if he had smoked it at all, what effects that joint would have had on Dr. Martin. This would just go and try and paint Dr. Martin as some sort of pothead and would substantially prejudice the jury against Dr. Martin.
Mr. Hargis, are you seeking on behalf of the state to read into evidence the lines 19 through 21 on page 3 of Mr. Trevino's deposition transcript?
Yes, Your Honor, and if I could respond to his objection.
And when you do so, if you will please guide the court with respect to how marijuana, a joint listed here, plays into the state's indictment.
Yes, Your Honor. As far as the marijuana on the day in question, Dr. Martin is charged with manslaughter and acting recklessly. This testimony goes to show that he was under the influence of marijuana before he went and treated his patient on May 9th, 2019. I believe this goes to the weight, not the admissibility of the evidence.
Brief response on those grounds, Your Honor.
Yes, defense, I'd like to hear your response.
Yes, Your Honor. Opposing counsel states that Dr. Martin was in fact under the influence. However, that is not stated in these lines, and there's no indication that that joint had any effect on Dr. Martin. Now, opposing counsel is trying to paint Dr. Martin as some sort of pothead, that he was so high out of his mind when he went to go treat Mr. Kherkher. However, there's no evidence to show that this joint had any effect on him or had any effect on the care that he provided.
I understand your objection. So, Mr. Hargis, is there any evidence that you can point the court to corroborate, other than just the smoking of the act of smoking the joint? But is there anything you can tell us or show the court, guide the court, that there was any sort of actual physical impairment, any loss of mental or physical faculties as a result of sharing a few laughs in a joint?
Your Honor, from this deposition, there's nothing else I can point to.
All right, counsel, I'll sustain that. Is there any further objection then from the defense to any other portion of this deposition transcript so that we can move on and not waste the jury's time?
Yes, Your Honor, that concludes the objections that the defense will raise.
All right, and so the rest of this, we can admit for purposes of this trial that all of this would have been read, correct?
Yes, Your Honor, that's fine with the state.
All right, state, do you have any additional witnesses to be called? I don't see any additional witnesses listed, but.
The state rests, Your Honor.
All right. Any motions to be made at this time, or can we proceed with the defense case?
Yes, Your Honor, we'd like to make a motion outside the presence of the jury.
All right, defense, you may proceed.
Your Honor, we'd like to move for a motion of a judgment of acquittal. The prosecution has failed to provide sufficient evidence to prove each of their elements where a reasonable jury member could find Dr. Martin guilty beyond a reasonable doubt. Specifically, Your Honor, the element that Dr. Martin was aware or knew his patient, Mr. Kherkher, was on hydrocodone. We haven't heard any testimony today stating specifically that Dr. Martin saw Mr. Kherkher ingest hydrocodone. We haven't seen any prescriptions today that show that Mr. Kherkher had a prescription for hydrocodone. In fact, the prosecution's own expert showed us evidence of the contrary, that Mr. Kherkher had no prescription for hydrocodone. When Mr. Kherkher had hydrocodone in his system, there's simply no way for Dr. Martin to have known that, and the prosecution has failed to meet their burden to show that Dr. Martin knew this fact.
Response?
Yes, Your Honor. You heard testimony from Dana Kittner Jr. that there was a pill bottle of pain medication sitting on the bedside table next to Dr. Martin's bed when he was in bed, and it was sitting right next to Dr. Martin's medical bag. That shows evidence that he saw the pill bottle sitting there. Further, Dr. Martin was aware of his patient's own past drug habits, and we believe this is enough for a reasonable jury to convict Dr. Martin based on what they've heard.
Yeah, I do think that reasonable minds can differ. I do think that there's a fact issue here, and I think that that is primarily created by what Mr. Hargis said about the exhibit number 1, the photo of the medicine bottle. So I'm going to deny the motion. But you have anything else that we need to take up before we start with the defense's case?
Your Honor, at this time, the defense just asked for a brief 5-minute recess before proceeding with the defense case in chief.
Anyone have any issue with that? I hope not.
No,
Nope.
Judge.
All right, let's take a 5-minute break then. All right, Mr. Jacobs, do we have everyone back?
It appears that we do, if the witnesses are ready as well. And I'll give a verbal reminder of my time check for the competitors. So state you're just over 29 minutes, defense just over 15 minutes, and that's in the chat. And I'll give you guys warning as we approach the 55-minute total limit, but good job so far.
All right, defense, are you ready to proceed with your case?
Yes, Your Honor. At this time, the defense calls Dr. Walker to the stand.
Where are we? Dr. Walker, you understand that you've already been sworn to tell the truth?
Yes, Your Honor.
Thank you for joining us. You may proceed with your questioning, defense.
Yes, Your Honor. Can you please introduce yourself to the members of the jury?
Yes, my name is Dr. Leslie Walker.
Where do you live, Dr. Walker?
I live in Armadillo Lone Star with my husband and my 3 kiddos.
Now, I understand that you're a doctor, but what kind of education did you receive to become one?
So I went to Yale University for my bachelor's in biology and physics, and then I went to Lone Star A&M Medical School, where I took my anatomy, my physiology, learned about toxicology and autopsy, basically everything that you learn in med school.
Now, what did you do for work after graduating?
Well, first I volunteered with Doctors Without Borders and I helped treat underprivileged people. And after that, I did accept a position at Mayo Clinic. And eventually when I wanted to settle down and have a family, I took a job with Armadillo Clinic.
So let's just talk about why you're here today. How did you get involved in today's case?
I was asked to look into the death of David Kittner and the conduct of Dr. Martin.
What did you review in coming to your conclusions today?
Well, I reviewed the autopsy report, the toxicology report, the medical records, and as well as all the other depositions for the other witnesses in this case. I actually believe that I was the last person to be deposed.
Dr. Walker, how do you know how to read an autopsy report and a toxicology report?
Well, like I said, in medical school, we were taught such things. As a medical student, I was taught that autopsy and toxicology reports are always involved in death cases. Our learning is from start to finish. I guess what I mean by that is that we start from pre-birth to post-death.
Now,
Defense counsel, do you mind if I interrupt for 1 second?
yes, Your Honor.
Dr. Walker, did you author a report in this case, a written report?
I gave my deposition, Your Honor, and I reviewed the autopsy and the toxicology report.
Okay, I was making sure. I was looking through the materials that I'd received and I'd not seen. I want to make sure I wasn't missing something before you proceeded too far. Defense, I apologize for interrupting. You may proceed.
Yes, Your Honor. So, Dr. Walker, based on everything you reviewed, what was your conclusion?
Well, I determined that Dr. Martin's conduct did not cause the death of David Kittner. Dr. Martin's actual actions were in line with.
Hold on, Dr. Walker. What is your objection, Mr. Gifford?
We believe that this is improper expert opinion, and we do not believe that the proper foundation has been laid for this expert.
Can you be more specific in terms of, and I don't want a long speaking objection, I'll caution you on that, but if you will tell me specifically what part of the foundation do you not think has been laid so that I can give defense counsel an adequate opportunity to correct that if it can be corrected? I'll add that caveat.
Yes, Your Honor. 2 quick points. First, we believe that the foundation laid does not comport with traditional foundations or the foundations as required by Doe-Bear. And the second point, Your Honor, we believe that the witness today was going to testify as to the reasonable mindset of the defendant, and we do not believe that that is appropriate testimony under the federal rules of evidence.
Right. With respect to the Daubert, I think I'm going to call it the Daubert motion is denied. I do want to hear the second part of that. I have not heard anything from Dr. Walker yet that would tell me she is a mind reader. And I don't know that, I'm not going to even assume that that's where you're trying to go, but can you respond to that, defense counsel, that second part on, and I forgot the exact language used, but go ahead on that.
Yes, Your Honor, we don't intend to admit Dr. Walker as a mind reader. She will not be testifying to the mindset specifically, just the evidence that she reviewed and the conclusion she came to based on the cause of death and what caused that death specifically.
So I will at this time enter a ruling that Dr. Walker is qualified to opine on the causation of death. And she's also obviously needs to give us the I think she's already told us what she's reviewed. If you seek to go outside the confines of causation, we're going to need to lay a little more of a foundation. Okay, counsel?
Yes, Your Honor, we'll keep it tailored just to the conduct.
All right, defense proceed.
Dr. Walker, can you please tell us again what your conclusion was in regards to the conduct of Dr. Martin?
Yes, I determined that Dr. Martin's conduct did not cause the death of David Kherkher. His actions, his conduct was in line with the standard of care for a physician.
Now, what factors did Mr. Kherkher have that affected your conclusion?
Well,
Well,
hold
Mr.
on now. We were just talking about causation, and now we're talking about the standard of care for a medical professional. Those are two different things. Can you lay a foundation for that, counsel?
Yes, may I respond, or would you like me just to lay that foundation?
I think that the best way for you to proceed is to lay that foundation first. Thank you, counsel.
Yes, Your Honor. Dr. Walker, how long have you been working in the medical field?
Well, immediately after graduating, I entered into the medical field for the Doctors Without Borders, forgive me. I graduated from Johns Hopkins and went straight into that.
And what kind of reliable principles and methods have you relied on in your work in the medical field?
So all the concepts that we were taught in medical school, as well as things like the physician's desk reference, taking continuing education to make sure that my standard of care is up to the most recent and the best practices.
So I just want to be clear then, have you been trained or are you familiar with the standard of care that's expected in your field?
Absolutely.
And have you reviewed the facts and evidence in today's case and applied your training and your methodology to those facts?
Absolutely.
Now, Dr. Walker, what factors did Mr. Kherkher have that affected your conclusion?
Well, several actually. Mr. Kherkher's high blood pressure, how overweight he was, his lack of exercise, his overall sedentary lifestyle, his rock and roll lifestyle. Also, the fact that Mr. Kherkher had quit abusing drugs was important. Typically, doctors are meant to rely on the statements of their patients before making medical decisions.
And Dr. Walker, you're going to have to explain this to me because I unfortunately did not go to med school. Why would a doctor rely on a patient before making medical decisions like that could lead to fatal consequences?
Well, doctors and patients have a confidential bond. And on top of that, there are certain scenarios where we have to rely on our patients. As much as we educate ourselves, as much as we try to get the truth, sometimes we do just simply have to rely on our patients in order to keep informed as to the status of their health, their symptoms, etc.
I appreciate that answer, but can you help me out a little bit more? Can you give us an example of this type of relationship?
Yeah, so picture you get appendicitis and you go to the hospital. The doctor asks you when was the last time you had something to eat or had something to drink. Now, the doctor doesn't have a way of running a test to get the true answer out of you. He has to rely on your word. And that's a situation where if the answer is something that isn't true, it could potentially be lethal, but still the doctor relies on your word.
Now, Dr. Walker, I just want to be clear. You were here throughout today's trial, right?
Yes, I have been.
And based off of the depositions that you reviewed, the evidence that was presented to you, and the testimony you've heard today, can you tell us if Dr. Martin gave Mr. Kherkher propofol?
Based on the evidence I reviewed, I can't conclude with certainty that Dr. Martin injected Mr. Kherkher with propofol, but even if she did, it would have been acceptable given the circumstances.
Well, we'll talk about both those options, but let's first assume that Mr. Martin had administered the propofol. Why would it have been acceptable?
Well, Mr. Kherkher had complained of shortness of breath. That's a common symptom of anxiety. Propofol is absolutely acceptable to be used as a way to combat anxiety.
Now, can propofol be deadly by itself?
Absolutely not. It's only lethal when it comes in combination with certain drugs.
Now, were you here when Ms. Kherkher Jr. testified?
Yes.
And did you hear the testimony about Dr. Martin's conduct after allegedly seeing Mr. Kherkher having a seizure?
Yes.
What is your opinion on that conduct?
Well, if Dr. Martin had administered adrenaline, it would be consistent with the standard of care and the standard of safety by administration of medication for a physician. It essentially would have been an attempt to bring Mr. Kherkher.
I'm going to re-urge. Your Honor, I'm going to re-urge the objection from earlier. We believe that under FR RE 704. This defendant is testifying as to the mental state, this witness is testifying as to the mental state of the witness or the defendant. As well, Your Honor, I believe that this is not relevant. I believe standard of care issues are more issues of malpractice or of negligence. This is a reckless homicide case, and I find that this evidence is inadmissible for those reasons.
Counsel, I do want to hear the response from the defense, but from the prosecution, Mr. Gifford, isn't substantial and unjustifiable risk as part of the indictment, correct?
Yes, Your Honor.
Okay, so your relevance objection is overruled, but with respect to the foundation, defense, can you please respond to
that? Yes, Your Honor. We've laid the foundation that the doctor is an expert in the medical field, that she's aware of the standard of care that's expected. And the witness was not testifying to the specific mindset of Dr. Walker, but the specific conduct and the actions that Dr. Martin took and why that fit the standard of care. This is what the doctor is being asked to. This doesn't go to any mindset as the prosecution states.
Let me do this. I'm going to hold on the objection. Re-ask your question based upon what you just told me. Okay, counselor?
Yes, you'd like to ask, or
I want you to ask your question again based upon your explanation of what this doctor is going to testify about. So if you'll give that an opportunity, let's take one opportunity for that question. I just want to make sure that I'm understanding this right.
Yes, Your Honor. The question is, what is your opinion on that conduct?
And the conduct you're referring to specifically, I need you to tailor your question to what is your opinion based on conduct X, Y, and Z. I don't want just a global question. Be specific, please.
I apologize. Yes, Your Honor. Now, Dr. Walker, what is your opinion on the conduct that Dr. Martin allegedly took after seeing Mr. Kittner having a seizure?
Yes. Well, Your Honor, may I respond? Forgive me.
Your Honor,
yes, you may. Counsel, your previous objection is overruled, but if another objection comes up, obviously you'll want to make it.
Thank you, Your Honor.
You may proceed, Dr. Walker. I apologize.
It's okay. If Dr. Martin had administered the adrenaline, it would be appropriate conduct as a physician. It would have been an attempt at bringing Mr. Kittner out of his seizure and cardiac event, because that's what the medication can do. But because Dr. Martin, but based on the fact that hydrocodone was not knowingly in the system, it had the opposite effect and took his life.
Now, let's talk about that other scenario where Dr. Martin was not the one to give Mr. Kittner propofol. Based on the evidence you reviewed, who else could have administered that propofol?
Well, based on on all the depositions, there are two other options: Mr. Kittner himself or his son, Davy Jr.
How long does it take to administer propofol?
20 seconds, if that.
Now, Dr. Walker, would it be helpful to the members of the jury for you to demonstrate how someone could self-inject?
I think it would be.
Your Honor, permission for this witness to make use of a demonstrative illustrating how an individual could self-administer something such as propofol?
And counsel, have you already shown this demonstrative? Have you already conferred with the state's counsel about this?
Your Honor, this isn't a pre-made demonstrative. The doctor is going to just physically show how one would administer this propofol.
I understand. This is a physical reenactment, if you will. Okay.
Yes, Your Honor.
State, do you have any objection to this?
Your Honor, we don't know anything about it. We're sure not at this time.
Okay. Dr. Walker, you may proceed. I will say, I think we understand this, so I don't want to spend a significant amount of time on it, but I'll grant you a little leeway. This is your case, so you may proceed.
Yes, Your Honor. I'll keep it to one question then. Dr. Walker, can you demonstrate for the members of the jury how someone could self-administer propofol, for example?
Absolutely. So this right here is the accessory cephalic vein. It's the most accessible vein possible, especially in men. With the syringe right here and with the needle right here, all you do is simply go straight in at this angle and the medication is administered.
Thank you, Dr. Walker. Now, you were also here when Dr. Jensen testified, right?
Yes, I was.
You heard the testimony that Dr. Jensen gave?
I did.
Do you agree that propofol can just be used for surgery and anesthesia then?
No, Dr. Jensen is incorrect. Propofol is used for several reasons. Surgery and anesthesia are two of those, but you can also use propofol for diagnostic procedures, sedation for anxiety, as well as for sedation for these diagnostic procedures.
So based on the two scenarios we explored, did Dr. Martin act outside of the standard of care when treating Mr. Kherkher?
No, regardless of whether Dr. Martin actually gave Mr. Kherkher propofol, Dr. Martin actually acted appropriately in his conduct.
Thank you for that, Dr. Walker. No further questions, Your Honor.
All right, Mr. Gifford, will you be questioning this witness?
Yes, Your Honor.
All right, you may proceed.
Good evening, doctor.
Hello.
Now, earlier you testified as to things you reviewed. You reviewed a series of reports.
Yes, I did.
And you reviewed a series of depositions.
Yes, the depositions for this case.
And it's your belief that David Kherkher died from a cardiac stress.
I believe that he died from basically cardiac stress caused by an accumulation of things.
So is that a yes, doctor? He died from cardiac stress?
Essentially, yes.
And cardiac stress, much like Mr. Abdelhafiz, I'm not well versed in medicine, but cardiac stress has to do with the heart, correct?
It has to do with the entirety of the body and how it affects the heart.
And so the heart and blood and veins and the like.
Amongst other things, yes.
And doctor, you weren't able to review this heart. Is that correct?
No, I did not see the actual heart.
Nor the veins and systems that you were talking about?
No, I didn't see his body opened up or anything like that.
Right, and you mentioned it's a system of the body and it encompasses the whole body, but you weren't able to see that body. Is that right?
No, I did not.
Now, doctor, you'd agree with me that propofol, when taken with hydrocodone, can cause stress on the cardiac systems, correct?
Yes.
And both propofol and hydrocodone was found in David Kherkher's body?
Yes, amongst other things.
And those two things did cause stresses on his cardiac system?
Yes.
Now, doctor, you mentioned something about trusting your patients, correct?
Correct.
And you gave an analogy that if a patient comes in and the doctor asks, have you eaten anything or drank anything, you have to trust your patient.
In those types of situations, yes.
In those types of situations. And you said there's no way to test if someone had anything to eat or drink. Is that correct?
No.
Was that your testimony?
Correct, yes.
And so, but there are ways to test for drugs, correct?
There are ways to look for symptoms and there are levels in the blood. As you could see, the toxicology report that I referenced is a way to test.
And you can find drugs in blood and bile and sometimes saliva.
Bile, no. Saliva, not to my knowledge, but urine perhaps.
Urine perhaps. And sometimes when you administer these harder drugs or get prescription for these more dangerous drugs, you have to give a urine or a blood test, correct?
Sometimes, not always.
Not always, but it's possible to not only trust your patients, but to test them as well, correct?
Yes, but not in emergent situations.
Now, doctor, you said throughout your deposition, you said if he administered adrenaline. Is that right?
Are you speaking as to the words in my deposition or my testimony? Sorry.
I'm so sorry. Your testimony today. You said if Dr. Martin administered adrenaline, correct?
Correct.
But during your deposition, you talked less in hypotheticals and you said that he did administer this adrenaline. Is that correct?
I don't remember the exact words I used during my deposition. Forgive me.
Doctor, I guess my question for you today is, do you believe that the defendant, Dr. Martin, used adrenaline on May 9th?
Well, I don't think I would be the appropriate person to say that because I wasn't there. So I
Mhm.
can't have a belief based in science. But based in science, I do believe that if he had, it would have been appropriate conduct.
Now, doctor, you talked about propofol and you talked about the veins. Propofol, it's a intravenous drug, is that correct? And
Yeah.
am I saying that correctly?
You did, yes.
Now, that means, as you mentioned, it must be administered through the veins, correct?
Correct, yes.
Now, an IV drip at the hospital, that also stands for intravenous, correct?
Correct.
And you showed us how to do that. You said that you have to inject it into the, was it phallic vein?
No, the cephalic.
Cephalic?
Yes.
And you pointed to it here.
Mm-hmm.
And you also said you have to do it at an angle.
Yes, but it's quite easy to get that angle, whether you're the administrator, well, self-administrating, or being an external administrator.
And you also testified that you have to find that vein as well. Is that correct?
It's very easy to see with the naked eye, so yes.
And you've been practicing medicine for how many years, doctor?
Oof, I don't know at this point, but ever since I came out of med school.
And it's very easy for you to find that vein. Is that right?
Actually, anybody. That's unfortunately why we have an epidemic right now. I don't know if you've heard about it, the opioid crisis. A lot of it you can self-inject, and that's why we have these stations now being built so that people can get medication quickly.
And you mentioned this opioid crisis. Hydrocodone is an opioid, correct?
Yes, it is.
And it's widely abused in the United States.
It can be, yes.
It can be, but you just mentioned this opioid epidemic. So it's one of the opioids that is abused in this country, correct?
It's one of them, yes.
Thank you. No further questions, Your Honor.
Any redirect?
No redirect, Your Honor. We just ask that this witness be allowed to step down.
All right, this witness is excused. Defense, you may call your next witness, please.
Yes, Your Honor. At this time, the defense calls Dr. John Martin to the stand. May I proceed, Your Honor?
Yeah, Dr. Martin, you understand that you've been sworn to tell the truth, correct?
Yes, sir. Yes, Your Honor.
You may proceed.
Yes, Your Honor. Good afternoon, Dr. Martin. Will you please introduce yourself to the ladies and gentlemen of the jury?
Yes. Hello, my name is Dr. John Martin.
And Dr. Martin, to mention the elephant in the room, can you please tell the ladies and gentlemen of the jury what it is you do for a living?
Yes. I am a general physician.
And finally, will you please tell us what is your understanding about why we're here today?
Yes. I have been accused of doing something that not only did I not do, but something that I would not do and could not have done.
What is that accusation?
And that would be ending the life of Special K.
Dr. Martin, who was Special K?
Special K was a music icon and legend, as you've all heard today. I met him back in the day through a mutual friend, Ted. We hit it off. He knew I was a general physician, so he asked me to come on the road with him as his personal physician.
And did you agree?
Yes, I did.
Well, Dr. Martin, can you tell us a little bit what it's like being a celebrity's personal physician?
Yeah. I traveled everywhere with him. When we did, we were all on the road, but he wasn't traveling so much towards the end of his life, towards the end of his career, excuse me. And so we were not on the road as much.
And what responsibilities did you have as Mr. Kittner's Special K's physician?
Yeah. I scheduled, and performed regular physicals, and I wrote referrals or prescriptions if I thought he needed them, and I reviewed his medical records when able to and available.
Dr. Martin, at the time of May 9th, 2019, how old was Mr. Kittner?
He was about 73 years old.
And prior to Mr. Kittner's death, what, if any, health concerns did you have?
Well, Special K was an older gentleman. He was overweight, and he had lived a pretty sedentary lifestyle. He also had heavy stress from his life on the road and touring and staying up late.
Your Honor, at this time, may I approach the witness constructively by sharing screen in order to show her Exhibit 1 that has already been admitted into evidence?
Is this exhibit number 1, the photo of the medicine bottle?
Yes, Your Honor.
You don't need to do so constructively. It's in evidence. It can be used for all purposes, counsel.
Okay. Now, Dr. Martin, you've been inside this Zoom trial this whole time, correct?
That is right.
And you heard Ms. Kittner testify earlier today that this bottle was found by her dad, right?
That is correct.
Dr. Martin, do you recognize Exhibit 1?
I do not recognize Exhibit 1.
Did you ever prescribe Exhibit 1?
No, I did not write any prescriptions for this.
To your knowledge, on May 9th, 2019, did Mr. Kittner Sr. have any prescriptions for hydrocodone?
From me, absolutely not.
Now, Dr. Martin, I want to talk about the day that Mr. Kittner passed. Where were you on that day?
I was sitting out at the pool with my girlfriend.
What were y'all doing?
We were hanging out at the pool watching TV, and that's when I got a call from David.
And what did you do in response to this call?
He asked me to come to his room repeatedly, and so I did.
What did you do once you arrived at Mr. Kittner's room?
Well, when he had called me, I asked him if he consumed anything, and he said no. So we went to his room to see what the matter was. And he said he was feeling tired and had shortness of breath.
Did you perform any kind of medical work on him?
Yeah, I just did a general observational physical like I had done many times before.
And what was the conclusion of your physical?
All I told him, just based on that physical, he just needed to relax and to take deep breaths.
So what did Mr. Kittner do in relation to what you told him he should do?
Yeah, we just got him in bed and I told him to relax.
Now, you mentioned we got him into bed. Who was with you at this time?
Oh, I'm sorry, just me and David. I got David into bed, but he was able to get him there.
Okay. Now, was it just you and Mr. Kittner the entire time?
At first, it was just us two.
What do you mean at first?
Well, once I had gotten him into bed and told him to relax and rest, little Kittner had come into the room quietly and caused quite the scene, yelling at me and told me to get out of the room.
So what did you do?
Well, like I had just told David to relax and rest, I didn't think the yelling was going to be helpful. So I walked out of the room because I did not want to be arguing with little Kit.
Dr. Martin, was that the last time you saw Mr. Kittner?
No, I went back to the room because I realized that I forgot my medicine bag.
Why were you concerned about your medicine bag?
I didn't want to leave my medicines unattended.
Was one of those medications this bottle of Vicodin?
No, absolutely not.
Okay, so were you able to retrieve your medicine bag?
Yes, I got it and I left again because all that David Sr. needed to do at that time was relax and take some deep breaths.
And what did you see when you went back to the room to get your medicine bag?
I saw little Kit slipping a syringe into his boot and he had something in his hand. I asked him what he was doing.
What happened then?
Well, I asked him what he was doing and he again yelled at me and kicked me out. He seemed really stressed and excited. And again, I didn't want to cause any more disruption, so I decided to leave.
And did you leave?
Yes, I did.
What happened then?
As I turned to leave, I heard little Kid say, "We got to go to the bank and transfer that money to my account. Get your start."
What's your response, Mr. Duarte?
Yes, Your Honor, this witness has just testified that the declarant she perceived was under excitement and stress, and therefore it is admissible under 803(2), the excited utterance exception to hearsay.
I tend to agree, Mr. Hargis. You want one attempt to change my mind?
Yes, Your Honor. I'm not sure how the statement, "we got to go to the bank," applies as an excited utterance under the situation.
Overruled. You may proceed, Mr. Duarte.
Let me ask that again, Dr. Martin. What did you hear Miss Kittner at this time as you were leaving?
Yes, I heard her say, "We got to go to the bank and transfer the money to my account. Get your sorry butt up and get a suit on."
Was that the last time you saw Mr. Kittner?
Yes, unfortunately it was.
And what was Mr. Kittner wearing the last time you saw him?
He was wearing this old Keep Austin Weird t-shirt and some gym shorts.
Now, Dr. Martin, you mentioned earlier that Mr. Kittner was a special friend of yours. How did you come to learn of his passing?
Well, I went back to the pool and the next thing I knew, the police had shown up and they let me know that there had been a death. And I later saw a photo of the way that Special K was found.
Would you recognize that same photo?
Yes, I would.
Your Honor, permission to share screen outside the presence of the jury for the purposes of offering an exhibit into evidence.
If you will lay the foundation first, yes, let's start with sharing, please.
Yes, Your Honor. Your Honor,
Counsel,
are you,
what exhibit number is this? I'm sorry, 5, okay.
Your Honor, are you able to see my screen?
I am, yes, thank you.
Dr. Martin, without getting into its contents, do you recognize what has been pre-marked for identification purposes as Exhibit 5?
Yes, I do.
And what is Exhibit 5?
It's Mr. Kherkher, Senior, in his chair, and when he's dead.
Hold on, Mr. Hargis, is the state objecting to the admission of this exhibit?
No objection to this, Your Honor.
Mr. Duarte, if you want to go ahead, we can admit this.
Yes, Your Honor. May it be published to the jury?
Yes, you may proceed.
Dr. Martin, I'm showing you what has already been admitted into evidence as Exhibit 5. Where in Mr. Kherkher's bedroom was Mr. Kherkher the last time you saw him?
The last time I saw him, he was lying on his bed.
At any time that day, was Mr. Kherkher wearing a suit?
I did not see him wearing a suit.
Now, Dr. Martin, you heard Ms. Kherkher testified today that her father was convulsing, correct?
Yes, that's right.
And how long had you been Mr. Kherkher's personal physician?
For quite some time.
Before that, or let me re-ask that. Was he your first patient?
No, I had my own general practice in Turkey before I met Special K.
Okay. Dr. Martin, we heard Miss Kherkher saying that her dad was convulsing in bed. In your experience, can a person that's convulsing get up?
With all due respect to Miss Kherkher, no.
Can they get out of bed?
No.
Can they walk around?
Likely not.
Can they change into a suit?
Likely not.
At any time on May 9th, 2019, did you observe Mr. Kherkher seizing?
No, I did not.
Now, Dr. Martin, on that day, were you wearing a suit?
I was out by the pool, so I was wearing a swimsuit.
Now, Dr. Martin, I want to talk a little bit about the contents of your medicine bag once you retrieved it. Were you ever able to go through it?
Yes, after the fact.
And did you notice anything particular about your bag?
Yes, I noticed that the propofol I had on hand for emergencies was gone.
I'm sorry. Sorry about that, Your Honor. Dr. Martin, why do you keep propofol?
Well, actually, as you heard Dr. Jensen say earlier, propofol can be used for emergencies, which is why I had it on hand.
Did Mr. Kherkher have a prescription for propofol?
No, he did not.
And so you notice your propofol is missing. When was the last time you had seen the propofol in your bag?
Well, I did not administer it. So it was in my bag before I went to see Mr. Kherkher, and then it was not in the bag once I checked it after the fact.
And who was in the room when you left your medicine bag in that room?
David and Miss Kherkher.
Dr. Martin, at any time, did you inject propofol into Mr. Kherkher?
No, I did not.
Did you give Mr. Kherkher hydrocodone?
No, I did not.
At any time, did you inject adrenaline into Mr. Kherkher?
No, I did not.
At any time of that day, did you prescribe any type of medication to Mr. Kherkher?
The only thing I prescribed to David Kherkher on May 9th was relaxing and taking deep breaths.
And why was that?
Based on the conversation we had had and the observational physical I did, I had no cause for concern other than that. So he only needed to relax and take deep breaths.
Your Honor, at this time, I have no further questions and I pass the witness.
Mr. Hargis, cross-examination.
Yes, Your Honor. May I proceed?
You may.
Thank you, Judge. Good afternoon, Dr. Martin.
Good afternoon.
Now, You testified on direct that you had never seen that pill bottle before. Is that right?
That's right.
But your name was on the pill bottle, correct?
Correct.
Now, you also testified that you used to travel a lot with Mr. Kherkher, right?
Yes.
So you were aware of his drug habits over the years, right?
Yes.
Now, on the day in question, Dr. Martin, you learned that Mr. Kherkher had been experiencing problems,
Yes.
and it was your belief that that was due to him exercising strenuously. Is that correct?
That is correct.
You never saw Mr. Kherkher exercise much, though. Isn't that true?
That's correct.
Mr. Kherkher was old and overweight, right?
Yes.
Now, Dr. Martin, when you left the cabana, you were with your fiance at the time, right?
Well, I had proposed to her that day.
And you said something to your fiance when you left the cabana, right?
I don't recall anything particular.
But you were here in trial today when the deposition testimony was read in, correct?
That's correct.
Didn't you say to your fiance, I'm going to go fix him once and for all?
No, I did not say that.
It's your testimony that you did not say that to your fiance.
That is correct.
So when you came back later, is it also your testimony you didn't tell your fiance you would fix the problem?
That is correct.
Is it your testimony here today that your fiance was lying about all those things?
Yes.
Now, the two of you had been celebrating your engagement, right?
That's right.
And you had been drinking?
I had had a couple drinks, yes.
Doctor, is it reasonable for another doctor to practice medicine while under the influence of alcohol?
I don't believe that I was under the influence. I had consumed alcohol and I wouldn't have answered the call if I couldn't have.
So, but you would agree that alcohol was in your system?
Yes.
And you would also agree as a medical doctor that alcohol impairs judgment, correct?
That's correct.
Now, you testified about the propofol that you had in your bag, right?
Yes.
In fact, you had it preloaded into a syringe in your bag, correct?
Yes.
Doctor, would it be appropriate for another doctor to inject a patient who's a known drug user with propofol?
Probably not.
You testified that you were aware of Mr. Kherkher's drug use over the years. Isn't that right?
Over the years, yes.
On May 9th, 2019, Mr. Kherkher was your only patient, correct?
Correct.
So the medicine in your medical bag was specifically for use for Mr. Kherkher, correct?
I'm sorry, can you repeat the question?
Sure, let me rephrase. He was your only patient, so the medicine in your bag would be used to treat Mr. Kherkher, correct?
Well, I had it on hand for emergencies. And whenever we did go on the road a lot, it's kept for emergencies. So if someone were to need it, I wanted to be able to have it.
So you had the propofol when you would travel on the road too. Is that right?
That's right.
Thank you. I have nothing further.
Any redirect?
Brief redirect, Your Honor.
You may proceed.
Dr. Martin, to put it blankly, were you drunk when you attended the call that your patient made?
No, I was not.
No further questions, Your Honor. At this time, we ask that this witness be excused.
All right, Dr. Martin, thank you. Defense, if your witness list is correct, I believe you have no further witnesses or additional witnesses, correct?
Yes, Your Honor, that is correct.
All right, defense, do you rest at this time?
Yes, we rest, and at this time, we'd like to make a motion outside the presence of the jury.
All right, you may proceed.
We'd like to re-urge our motion for a judgment of acquittal under Rule 29. The prosecution has provided insufficient evidence to show that Dr. Martin knew that Mr. Kherkher was on hydrocodone, and we have seen no evidence to show that Dr. Martin actually injected the propofol into Mr. Kherkher. In fact, we've heard testimony today that from Dr. Martin, herself that she didn't inject propofol. We've heard testimony today from this prosecution's own expert that the prosecution's expert believed Mr. Kherkher had self-administered that propofol. We've heard testimony today from the defense expert on showing how easy it is to self-administer. The prosecution has failed to provide sufficient evidence to show that Dr. Martin actually injected that propofol. We have no idea how much propofol was in the system, how much adrenaline was in the system, how much hydrocodone was in the system, and when it got into the system. This was all testimony that the prosecution's expert had to admit.
Anything else, counsel?
No, Your Honor, we just re-urge our motion.
Mr. Hargis, Mr. Gifford, who wants to respond to that argument?
I'll respond to that, Your Honor.
Please
And
proceed.
I would make the same arguments I made earlier. For one, we had direct testimony here today that Dana Kherkher Jr. watched Dr. Martin inject medicine first into Mr. Kherkher, leave the room, and then come back and inject more medicine. We also had her testimony that that pill bottle was sitting right next to the bedside table. Now, Dr. Martin claims to not recognize this bottle, but his name is on it, and I believe that still creates a fact issue. Dr. Martin also just testified that she was aware of Mr. Kherkher's drug use over the years, and that she had the propofol preloaded into her syringe even back when she was traveling with Mr. Kherkher back in the day when she experienced Mr. Kherkher using those drugs.
All right, motion's denied, but I appreciate the argument from counsel. Any other motions, anything else that we need to take up at this time?
No motions, Your Honor. We just ask for a brief 5 to 10 minute recess before the closing arguments commence.
Why don't we do this? And I'm sure right now I've got 5:05. Why don't we plan on 5:12? Does that work?
Yes, Your Honor.
Yes,
Thank you.
All right, we'll see y'all then. Thank you. Brief recess. All right, we ready?
It appears that everyone's here.
All right, anything that we need to take up before we wrap this up?
Your Honor, if I may, as the defense lawyer, Gomez Duarte, just a reminder to the court and the bailiff that we can get the 5, 3, and 1 minute warning in the chat.
That works.
Thank you, Your Honor.
And for the prosecution, are you going to have and obviously you're going to do the opening remarks. You're going to have save time for rebuttal.
Yes, Your Honor, I'd like to reserve 2 minutes for rebuttal.
All right, 2 minutes for rebuttal. Bailiff, can you handle that, please, sir?
Yes, sir. Not a problem.
Wonderful. All right, and Mr. Hargis, you may proceed with closing statements.
Thank you, Judge, and may it please the court.
Proceed.
A doctor's top priority is always the health and safety of their patient. Doctors abide by what's called the Hippocratic Oath, which says, I will use those dietary regimens which will benefit my patients according to my greatest ability and judgment, and I will do no harm or injustice to them. Folks, the evidence has shown you today that Dr. Martin violated this Hippocratic Oath, and in doing so, committed the crime of manslaughter. Now, I expect the defense to get up here in a minute and talk about the burden quite a bit, about how it is such a high burden, and I agree, it is a high burden. It's proof beyond a reasonable doubt, but not beyond any possible doubt, just beyond a reasonable doubt. Folks, I would represent to you that that burden isn't that high, and Mr. Gifford and I have met it today. In fact, we convict people every day that had that same burden. And you will see in just a moment, all the evidence that you've heard today shows that we met our burden here in court today. Now, before we talk about the evidence, I want to briefly go over the instructions and the elements of manslaughter that the judge has instructed you on. Today, we were required to prove the crime of manslaughter beyond a reasonable doubt. And under the laws of this state, a person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. Now I want to talk about the evidence that you heard here in court today. You heard first from Mr. Kittner's daughter, Dana Kittner Jr. She told you that she saw Dr. Martin inject her dad with something and then hid the syringe in their pocket. Dr. Martin was surprised when she saw Miss Kittner had been there to witness all this go down. And then, according to Miss Kittner, Dr. Martin left the room for several minutes and then came back and started injecting Mr. Kittner with more drugs. And lastly, after Dr. Martin has injected these different drugs, they just leave again. They leave Mr. Kittner, her patient, in the hands of a 17-year-old girl to just watch her father die. Now, the defense is trying to point to Mr. Kittner as the one who injected these drugs, but you heard Ms. Kittner testify. She had no experience whatsoever in injecting drugs into someone's veins. She didn't even recognize what propofol was at the time of her father's death. Now, you also heard Ms. Kittner testify about a medicine bottle that was sitting right next to Dr. Martin's medical bag on the bedside table, a medicine bottle that was hydrocodone. Lastly, the defense tried to bring up Ms. Kittner being the sole beneficiary of the estate, but you heard from Ms. Kittner herself. She was not aware at the time of her dad's death that she was the sole beneficiary of that estate. Now, the state also brought an expert here today, and that was Dr. Jensen. You heard from Dr. Jensen that Mr. Kittner's death was the result of a massive heart attack caused by the combination of propofol, adrenaline, and hydrocodone. Now, you also heard that Mr. Kittner did not qualify as someone who would need propofol, and that he had no prescription for propofol. Dr. Jensen also said, very importantly, that it was not appropriate or normal for doctors such as Dr. Martin to carry around a preloaded syringe of propofol in their medical bag. Now, you also heard testimony today of Bree Trevino, a sworn deposition that was introduced in court, that Mr. Trevino had observed Mr. Kherkher carrying around baggies of powdery substances in the weeks leading up to Mr. Kherkher's death. Mr. Trevino lived in the house with Mr. Kherkher just like Dr. Martin did and observed all these things leading up to Mr. Kherkher's death. You also heard testimony from Mr. Trevino that Dr. Martin told him on May 9th, 2019, that she was going to, quote, fix him once and for all, him being Mr. Kherkher. Then Dr. Martin leaves the cabana and returns 15 minutes later, and Dr. Martin tells Mr. Trevino that she had fixed the problem. Now, the defense also put on some witnesses here today, and you heard first from their expert, Dr. Walker. Dr. Walker, who never actually examined Mr. Kherkher's body after his death, wasn't able to see Mr. Kherkher's heart. And unlike the expert that the state put on, Dr. Jensen, who was the one who conducted the autopsy and reached his conclusions. But you also heard Dr. Walker testify that propofol must be administered through the veins, something that a doctor is trained to do, not something that a layperson, such as a 17-year-old girl, Dana Kherkher, or Mr. Kherkher himself. Lastly, you heard from the defendant, Dr. Martin. You heard Dr. Martin say she thought her patient was exercising. Her old and overweight patient, who she had been around for years and rarely saw exercise. You heard that Dr. Martin was fully aware of Mr. Kherkher's drug use over the years because she had spent basically her whole time with him while traveling out on the road. You heard that Dr. Martin had been drinking that day before she went and treated her patient. Dr. Martin claims to have never seen this medicine bottle that's sitting there. The fact is, folks, Dr. Martin's name was on the bottle as the prescribing physician. Lastly, you heard Dr. Martin admit that she carried propofol in her medical bag. That preloaded syringe with propofol in her medical bag that Dr. Martin used for treating her one patient. That one patient was Mr. Kherkher, who she knew to be a drug user. Now, based on all this evidence that has been presented here today, the state has met its burden of proof beyond a reasonable doubt that Dr. Martin is guilty of manslaughter. We have proven that Dr. Martin was the one that injected propofol into Mr. Kherkher. We have proven that Dr. Martin injected adrenaline into Mr. Kherkher. And we have proven that Dr. Martin was aware of Mr. Kherkher's drug use and the hydrocodone. In fact, that bottle of hydrocodone was sitting right next to Dr. Martin's medical bag on that bedside table while she was treating her patient. Dr. Martin was further reckless in injecting the adrenaline after being aware of the hydrocodone and after injecting the propofol. And it was these reckless acts, folks, that led to Mr. Kherkher's massive heart attack and tragic death. But based on all these things, we are asking you today, when you go back to that jury room in a few moments, we are asking that you do what the evidence has commanded you to do here today, and you find Dr. John Martin guilty as to the crime of manslaughter.
Thank you, Mr. Hargis. You're going to reserve the rest of your time.
Sorry, was that a question, Judge?
Are you going to reserve the rest of your time?
Yes, Judge. I'll only need a couple of minutes.
All right. Ms. Duarte, closing.
May it please the court.
It may, you may proceed.
Relax. Take a deep breath. That is the only treatment Dr. Martin prescribed Mr. Kherkher on May 9th, 2019. Members of the jury, as you recall from jury selection, my name is Laura Gomez Duarte, and I, along with my co-counsel, Youssef Abdelhafiz, have the privilege of representing the defendant in today's case. The defendant today is Dr. Martin. Now, you heard from Dr. Martin today. She's been a personal physician for Mr. Kherkher for a long time. She lived on his property. And to an extent, we agree with the state that a doctor's top priority should be the care, the health, and the safety of their patient. And Dr. Martin did just that by listening to her patient, by trusting her patient, by prescribing treatment that was adequate for that patient. Now, today, the state alleges that Dr. Martin is the reason that Mr. Kherkher is no longer producing music for all of us. Because they brought such a serious allegation, the state has the burden of proving to you beyond a reasonable doubt. Now, I disagree with Attorney Hargis in saying that this is not the highest burden. Members of the jury, our legal justice system is based on the foundation that everyone is innocent until proven guilty beyond a reasonable doubt. Reasonable doubt is that question in your gut telling you that the prosecution's theory just doesn't add up, that it doesn't make sense. And the law requires you to find a defendant not guilty if you have reasonable doubt. It's not you can if you want to, you must. The law requires it because it is such a high burden for the state to prove. Now, Mr. Hargis just read the instructions that Judge MacLeod will give to you. But let me remind you today that the state had to prove three things. Number one, the defendant, Dr. Martin, was aware that Mr. Kherkher had hydrocodone in his system. Two, that despite knowing, Dr. Martin knowingly, consciously disregarded any substantial and unjustifiable risk by injecting Mr. Kherkher with propofol and adrenaline. And three, that the combination of these drugs that Dr. Martin allegedly injected was the reason that Mr. Kherkher is no longer with us. Members of the jury, today you heard from 5 witnesses. First, you heard from Ms. Kherkher, Mr. Kherkher's daughter. Now, Ms. Kherkher told you today that she inherited nearly $500 million estate with her father's passing. The state has not proven to you not only that Mr. Martin did not do this, that Dr. Martin did not do this, but the reason. Why would Dr. Martin do this? Why would Dr. Martin knowingly, consciously disregard and cause the death of the person that's paying their bills, of their longtime friend, of a person they've been monitoring to make sure that they don't do drugs? It just doesn't make sense. Why would they do this? The state has failed to provide you with that answer. And I encourage Mr. Hargis to answer this question. Why would the defendant do this? Why would Dr. Martin do this? I'll tell you why he didn't do this. Dr. Martin had no idea that Mr. Kherkher had hydrocodone in his system. Ms. Kherkher told you today she saw a bottle in her father's room, a bottle of hydrocodone with her name on it. A bottle of hydrocodone that only Ms. Kherkher remembered seeing, and a bottle of hydrocodone that only Ms. Kherkher acknowledged was in the room with her father. Now, I agree with Mr. Hargis that there is an opioid crisis, and Mr. Gifford made it clear that it is affecting millions of Americans. And the reason why it is because Americans are able to inject and administer these drugs to themselves. You then heard from the state's expert witness, Dr. Jensen. And Dr. Jensen also adds clout to this theory because Dr. Jensen admits that his opinion was that Mr. Kherkher not only had hydrocodone in his system, but self-administered the propofol. But that's about the only thing that Dr. Jensen could tell you, because I kept tally, and I'm sure that you did too, ladies and gentlemen. There were about 9 things that Dr. Jensen did not know. My co-counsel, Mr. Abdelhafiz, reiterated that you weren't there, you didn't see this, you don't know that. And Dr. Jensen had to agree because that was the truth. And one of the things that Dr. Jensen agreed was that Mr. Kherkher had no hydrocodone prescription. So Dr. Martin couldn't be aware that her patient was on hydrocodone. Further, all doctors take ethics classes and know that the administration of drugs that are not needed is not ethical. And third, that there were 3 times the amount of propofol in Mr. Kherkher's system. Ladies and gentlemen, you saw the autopsy report. It's not in there. It's not in the toxicology report. And when asked by my co-counsel, Dr. Jensen had to agree that that number was brought up out of thin air. We don't know how much hydrocodone was in Mr. Kherkher's system. We don't know how much propofol was in Mr. Kherkher's system. We don't know how much adrenaline was in Mr. Kherkher's system. And to come to the conclusion that these so-called drugs were the reason that caused Mr. Kherkher's death is based off nothing. Finally, you heard from Bree Trevino. Now, they weren't able to be here today, but their deposition was read. And when you're able to recall that deposition, you remember that Bree Trevino had a short-term memory loss. They're saying statements and they don't remember. So it's probably true that Dr. Martin never said anything about fixing anyone. Now, you did hear from Dr. Martin, and Dr. Martin told you that she would never administer propofol to Mr. Kherkher. Yes, she carried it around. Yes, it was for emergencies. She's a doctor. It's her top priority to be the care, the health, and safety of her patient. But she did not administer propofol that day because Mr. Kherkher did not need it. Dr. Martin performed a physical evaluation, as she told you. She came to a conclusion based on her experiences, based off of what her patient told her. And she prescribed the only thing that was necessary. Relax, take a deep breath, bed rest. The only mistake Dr. Martin did that day was leaving her medicine bag unattended with a dopey young kid, Miss Kherkher. Now, members of the jury, early in today's trial, Mr. Gifford told you about a drug dealer. He insisted that Dr. Martin was some kind of drug dealer. Dr. Martin is a doctor. And I reiterate, why would a doctor take away a close friend, take away the reason that she has a job, a place to live? It doesn't make sense. Further, Dr. Martin told you about the health concerns that she had of her patient at the time. Now, Mr. Kherkher, as much as we loved his music, I think we can all agree that he was an older gentleman. He was 73 years old, and much like me and my family, overindulge a little bit in the eating, tend to be a little overweight, sedentary lifestyle. Mr. Kherkher also had a lifetime of rock and roll, living on and off the road, doing drugs. And all of these stressors together, when you combine the age, the lifestyle, the past drug addiction, it makes you more susceptible to cardiovascular disease. So members of the jury, you must consider the 3 elements that the state had to prove to you. And again, I barter this question because when I was asking questions to Dr. Martin and Ms. Kidner, you'll notice there was a really big discrepancy when it came to what everyone was wearing. Let me remind you of this photograph. This photograph is how Mr. Kidner was last found. He's wearing a suit. Now, if you chose to believe Ms. Kidner, her dad is in bed having a seizure, and somehow she doesn't remember where he is, even though it's a very important day. Members of the jury, it just doesn't make sense. The state's theory just doesn't make sense. But now what Dr. Martin told you is what happened. She saw Ms. Kidner take a syringe, probably from her medicine bag, tell her dad, "Dad, get up, put on a suit. We need to transfer the money to my account." That's why Mr. Kidner's in a suit. That's why Mr. Kidner's in a chair. That's why Ms. Kidner inherits over $410 million. That's why Ms. Kidner is the only one to benefit from this death. That's why Ms. Kidner is the only one to recognize hydrocodone. That's why Ms. Kidner's name is on the bottle of hydrocodone. The defense's expert today, Dr. Walker, made it clear it's so easy to inject medications through syringes. Whether it was Mr. Kidner, whether it was Mrs. Kidner, at the end of the day, there's reasonable doubt that Dr. Martin had anything to do that day with what happened to Mr. Kidner. Relax. Take a deep breath. That's the evidence that you must consider today, members of the jury. Not what I've said, not what Mr. Hargis has said. That's not evidence. You didn't hear anything today about a Hippocratic oath through any of our witnesses. You didn't see that introduced into evidence. You can't consider what an attorney says. You must consider the facts that you saw, the exhibits that were admitted, and the testimony that you heard. That is the only evidence that you must consider in this case. And like my co-counsel, Mr. Abdelhafiz, told you at the beginning, you have to separate the feelings from these facts and realize there's 3 big, giant holes in the prosecution's theory. They can't prove that Dr. Martin knew there was hydrocodone in the system. They can't prove that Dr. Martin made the decision to administer propofol and adrenaline. And they can't prove, and they did not prove, that it was this combination of drugs that caused Mr. Kidner's death. Because they failed to prove any of these elements, when you go back to jury deliberations and you receive your jury form, you must click not guilty for Dr. Martin, because it is the only conclusion that the evidence supports and justice demands. Thank you.
Thank you, Mr. Duarte. Mr. Hargis?
Relax, take a deep breath as I inject this propofol and adrenaline into my patient who I know abuses drugs. That's what Dr. Martin did on May 9th, 2019. Why did she do those things? Because she was treating her patient under the influence of drugs and alcohol, and she was reckless. Now, defense just got up here and spent a lot of their time trying to blame Miss Kidner, a 17-year-old girl, of killing her father, or that Mr. Kidner injected himself. But as we've already discussed, they have presented to you no motive for Miss Kidner wanting her father dead. Their entire motive rests on Miss Kidner collecting an inheritance that she knew nothing about until after the events of May 9th, 2019. Or this defense would have you believe that Mr. Kidner somehow first injects himself with propofol, starts convulsing, and then is able to again find a vein and inject himself with adrenaline. These wild theories presented to you by the defense are just that. They're wild and unreasonable. The fact of the matter is, folks, it's Miss Kidner who's the one who had the courage to come here to court today and testify for the state in pursuit of justice against her father's killer. And the evidence has shown you beyond a reasonable doubt that the person who was responsible for her father's death, the only person who recklessly caused her father's death, was Dr. Martin. Therefore, the law requires you to convict Dr. Martin of manslaughter and send her to prison where she belongs.
All right. Thank you, Mr. Hargis. Thank you, counsel. That will close evidence. Good job, y'all. All right.
I think this is where Stasha would like the three of us to go into a breakout room and talk amongst ourselves. So I'm going to do that real quick. Hold on one second. All right, so Judge MacLeod, Justice Countess, there should be an invitation to go to room 2.
Judge Weems, should we be joining the room? Brett, did you get an invitation for a room?
Yeah, to room 1.
Okay, same. Let's just see what's up.
Okay.
Let's see. Stasha, we're back. And
Hey, what's up?
Hey, I think Judge Coutiss is going to come out. You want me to shut down all of the breakout rooms and get everybody back in?
Yes, please.
They have 60 seconds to come back. Do you want us to give feedback first, or what do you want us to do?
I was thinking, for the sake of the live stream, if you guys announce it, kind of like, what's your verdict, just so that those viewers who kind of want to know who won don't have to wait.
They can fast forward to the end. They can,
but we have so many. I have some live stream texters, and they're like, "Who's winning? Want to know?" I'm like, "Well, you guys got to log on," but just trying to please the crowd.
Okay.
Absolutely. Do we have everybody? All right, so we had, first off, I just want to tell y'all that you did a great job. I hope that you know that. And I do. I mean, I reiterate that y'all, first off, just getting here is hard. It is. And then it's Sunday night. I know y'all have other stuff to do. I thought y'all just did an excellent job. You were prepared. We discussed it, and not guilty. It was our verdict. It's a defense verdict. And I'll tell you, I mean, honestly, it was a very, very close call. I mean, and I mean that. It's not just one of those lawyer bluffing, make you feel good. I mean, it truly was a close call. And then the best speaker award, Youssef. And I'll tell you the reasoning for that. I have to tell you, when I think of best speaker, I think of best advocate. And it's not just one time talking, it's every time. So literally every time you opened your mouth, I thought you were smart. I thought you were quick. I thought you were incredibly prepared. I think I threw you a couple of kind of, fastballs, curveballs, whatever you want to call it. I thought you handled it very well. And so when you just put all those things together, I thought you did a great job. That goes for everybody, though. We can give all of our feedback, but I thought y'all just did a great job. So thank you for letting us be a part of this. It's fun. So well done. Very.
And thank y'all for y'all's time. I'm sure we're going to do this later as well, but we really do appreciate the time and the feedback. It's also Sunday night for y'all too. So we definitely appreciate y'all being out here.
Yes, thank you so much.
Yep.
Thank you.
And on behalf
Thank
of,
you.
obviously, the tournament directors, thank you all so much. It's a great final.
Do you want us to go ahead and give a little feedback right now? That way it's on
I
the
think
recording
yes.
for
I
anybody
think
who
that
wants
our
to-
advocates would like to know that. I don't know if you guys are comfortable live streaming it. I mean, you could, but
I don't care.
yeah, I think for the sake of our viewers, they don't need to know.
Do you want me to cut it off, or? Okay. But that way other people can learn, Stasha, in the future.
I'm just thinking about my competitors. So,
Hey,
Weems, you can't give my secrets away.
yeah,
all right.
we've got some proprietary information on the call. So,
I'm ending the stream now. Thank you, everybody.
Bye.
bye,
Wait.
everybody.
Bye, Mom.
Yeah, exactly.
All right.